MP, Sri Lanka, and Secretary of State for the Home Department.
Lord Toulson will explain the decision of the court.
The appellant is a Sri Lankan who came to this country 11 years ago at the age of 28. He came on a student's visa, which was extended for 3 years. When it expired, he sought asylum here because he'd been a member of the Tamil Tigers and had been detained and tortured by the Sri Lankan security forces, and he feared similar treatment on his return. His application for asylum was refused because after the end of the Sri Lankan Civil War, the Home Secretary did not consider that he would be under any future threat. He appealed. He claimed to be entitled to protection under 3 international instruments, that is, the Refugee Convention, the European Qualification Directive, and Article 3 of the European Convention on Human Rights. He lost in part and won in part. He lost his appeal under the Refugee Convention and the Qualification Directive, but he won under the Human Rights Convention, and the decision of the upper tribunal was upheld by the Court of Appeal. This appeal is concerned with the Qualification Directive, which applies to all member states of the EU. Under the directive, a foreign citizen is entitled to what's called subsidiary protection status if he or she doesn't qualify as a refugee, but has shown substantial grounds for believing that he or she would face a real risk of suffering serious harm were they to be returned to their country of origin, and against which that country cannot provide protection. The facts of this case are unusual. The upper tribunal was not satisfied that the appellant would be at risk of any active future ill treatment. But because of his past torture, he is severely mentally ill and is highly suicidal at the thought of being returned to Sri Lanka. And there are no adequate psychiatric facilities in Sri Lanka able to cope with his condition. The question of law which arises in these circumstances is whether the Qualification Directive applies to someone who is at real risk of suffering serious harm if returned to their country of origin, not from future ill treatment, but as a result of past ill treatment by the state. Because the Qualification Directive is a European directive, it must have the same meaning in all member states, and that question is ultimately one for the Court of Justice of the European Union. Since the point is reasonably arguable either way, and there is no decision of the Court of Justice which is directly in point, this court has unanimously decided that it should be referred to the Court of Justice, and that is the course which we take.
Thank you.